Yeah, sure.
Just wanted to clarify that what you mentioned about veto at the Security Council. Actually, the United States could not veto the arrest warrant against Bashir because it was like a decision from the court. What they could have done would be to support an Article 16 deferral.
Yeah, right.
I just wanted to clarify that. Yeah. An Article 16 deferral would mean that the United Nations Security Council, which referred the situation of Sudan to the court, would vote to take the situation out of the hands of the court for a limited period of times if it decides that it should do so. And as you mentioned, there was no vote on this issue.
This is an interesting point because we have heard mentioned a couple of times the fact that there were a number of African governments who went along with the idea of limiting the indictment of Bashir. What they tried to do was encourage the Security Council to adopt such an Article 16 resolution, that is, to delay the indictment. And they did so because, interestingly enough, Muammar Gaddafi was the chair of the summit that took place, and I've read some reports that he used a number of parliamentary tricks to actually ram this through when there were a number of states that had serious reservations about the resolution supporting the withholding of the Bashir indictment. Botswana was adamantly opposed to any limitation on the indictment of Bashir. And there were other states that were clearly not fully alongside Gaddafi. But it was Gaddafi's, some people say, fairly dirty political moves in the course of the politics of the summit that brought it to pass.
Of course, U.S. participation is particularly important at this time because of the discussions that are ongoing and are, I guess, coming to some sort of a head with respect to defining the crime of aggression. And are there any comments that you might have in terms of time frame? How important is that?
That the definition comes forward?
Yeah, the whole discussion and also whether or not they're close to any type of final report.
Well, you know, as the crime of aggression is explicitly mentioned in the Rome Statute, of course we look forward to having a definition for it so that the Rome Statute gains more force and is a ready-to-use document. What we're looking now for is the review conference of the Assembly of State Parties of the ICC, which will take place in Kampala in 2010. And among other issues, the issue of the definition of the crime of aggression will be addressed. What the Assembly of State Parties has been doing is that it created a working group on the definition, and as far as I know, they have been working a lot on the issue. Of course, it's a very complex issue, and it will require a lot of negotiation. But I think one of the major dates to look forth is the review conference to see where they have arrived to and whether we will have a decision on it soon.
And this is of great interest to the United States because the kind of thing that you've heard as an argument against the International Criminal Court is an application of the crime of aggression to the United States every time the U.S. undertakes any sort of military activity. And so that the U.S. if I were grading them, they would be participating because they have an absolute interest in participating in this definition process and constraining, having a notion of how the U.S. behavior ought to be channeled and ought to be constrained, having some some input in this process of coming up to a definition. But by staying out of the discussion, you stay out of the chance to define the term. And the one thing I know from negotiation is you want to be there making the draft. You want to provide the draft. If you provide the draft, you win the negotiation.
You want to have the pen, the typewriter. Do you have any comments about U.S. involvement?
Well, what I would like to say is that according to the Rome Statute, the jurisdiction of the court is complementary, again, as Antonio discussed here. So in case the judicial system in the United States is unwilling or unable to pursue any of these crimes, the situation does not arise that the U.S. is taken to the ICC or any person in charge or any perpetrator of the crime is taken to the ICC. So I think that the worry of the U.S. is somewhat baseless. Up to, according or pursuant to the Rome Statute, we don't have a case that the U.S. will be taken there, because I think that the judicial system in this country is both willing and able to prosecute such crimes.
Well, how does the military feel about that?
The military
Yes.
feels that they have deployments to many, many countries around the world, and many of those countries are signatory countries to the ICC. And if U.S. military personnel were to commit an act within a signatory country that could be characterized as a war crime, then U.S. citizens could wind up before the International Criminal Court. At least that's what they think. They think that's what the possibility would be. If the definition is too broad a definition, it is too broad for a U.S. court to see as qualifying as a criminal act that could be characterized as aggression, then it might be that U.S. courts would not move forward. If it were seen in a court that is signatory to the convention, that the act was within their notion of the definition of aggression, this is the nightmare scenario. This is the one the military always imagines.
What is the feeling at the court about whether or not that's a realistic concern?
The definition of crime of aggression?
And, and whether or not the U.S. would be exposed.
Well, I think what Shirin said is absolutely true. The fear at the beginning that we heard a lot was that we would have a rogue prosecutor that would initiate investigations baselessly or, following a political agenda. And I think, we have proven 7 years on the going that this is absolutely not the case. All the investigations, all the proceedings that we have opened have been based solely on what's written on the Rome Statute, based on the law and on the full application of the law. What the Rome system does, and what is incredible of the Rome Statute, is that it basically creates one single standard for the whole of humanity, which is the respect of the rule of law. So if you do that, and I think, as Shirin said, the United States have courts that can absolutely do that and that have been doing that, then there's absolutely no reason to fear an intervention of the ICC. But at the same time, it is, I think, important to know that if your courts do not do the job that they should do, and I'm not talking about the United States, I'm talking about any country, then you have a further step, and you have a court that will step in if it's necessary and deal with this sort of crimes, because we're not talking about a burglary or petty crime. We're talking about war crimes. We're talking about thousands of people killed, raped, displaced, genocide. We're talking about crimes that need to be addressed. But in the case of the United States, I think the complementarity principle is pretty straightforward. So